Hello everyone, you are welcome back to the channel. For those that are here for the first time, please subscribe, share and like our page. Now today we'll be discussing a very important matter, and that is, can a party who has been sued on the subject matter, who has been taken to court on a particular subject matter of civil dispute, be taken to court over the same subject matter by the said party, his previous, that is his children, his agents or his lawful attorneys, over the same subject matter again? What does the law say, regarding this? Maybe as a result of, new evidence, the party feels that there are new evidence, emerging facts, that if he has used those facts and those evidence in the earlier case, the outcome of the case would have been different. And maybe he now feels there's a need to relitigate over the same matter. What does the law say regarding to this? Now, the principle of law on this matter is called res judicata. That is the estoppel per rem judicata. Parties, what the law says is, when a matter has been decided on the merits of it, once a matter has been litigated, the law does not allow a party in that same matter to, relitigate over the same matter again. So what this principle means is that there should be an end to litigation. Now, the local classical, that is the Supreme Court authority on this, is the case of Nkemdilim versus Madukulu, and the conditions and precedents laid down in that case is, number one, that the subject matter of dispute is the same. The parties may be the same, and the subject matter now becomes different. Maybe the case earlier litigated upon is land A, although the parties are the same, and the new matter is land B. The fact that land A has been litigated upon by the same parties does not mean that the same parties cannot litigate on land B. So if the earlier matter was on land A and the current matter is still on land A, land A, the condition for one of the conditions for estoppel per rem judicata or res judicata is already fulfilled. Now, the second one is that there was a final judgment. The judgment in the earlier matter was not interlocutory. It was a final judgment of court, deciding the matters on the merit of it. So the matter has been decided by the court, maybe at the final court, or there's no subsisting appeal. So if that happens, that the second condition has been fulfilled. Now, the third condition, which is also one of the most important conditions, is that the parties are the same. The same parties that litigated in the first case are still the same parties, that are here to relitigate on this, on another, on the same particular subject matter. Now, it doesn't matter whether these parties are not the same in the literal sense of it, but they are children. Maybe the parties that earlier litigated on the matter are already late, they are deceased. Then their children now feel, so our fathers did not do this matter well. They see the file somewhere, decided to dust it and take the matter to court. Or they felt like maybe the judge that did the earlier matter did not appreciate the facts of the matter very well, did not appreciate the evidence, did not evaluate the evidence properly. And they now feel like, okay, if we do it in another court, we'll get judgment in our favor. What the law says is that once these three conditions are met, you cannot litigate over the same matter. But note, this principle does not mean that another party, whether or not if you have judgment on a particular land, that another party is an interested that is not linked to the earlier parties we mentioned at all. Maybe it's not a privy, it's not a descendant, it's not from the family, it's not an agent, it's not a lawful, or has no, it's not under any authority of the other person. So it's legal authority to act for and on behalf of them to sue you, that cannot sue you. If the party is a different party altogether, irrespective of the fact that you already have a judgment on that piece and parcel of land or any property at all. It's not restricted to land. It can be on anything civil at all. Irrespective of the fact that the person, you already have a judgment in that, on that particular, subject matter, any other party can sue you. So that goes to say that the parties must be the same, judgment must be final, and the subject matter must be the same. So thank you for watching. You are welcome. Don't forget to like and subscribe to our channel. Thank you.